If you are a student loan borrower and you are enrolled in a SAVE plan, then you already know there's just been a lot of madness with the SAVE plan. And this has been going on since when the Biden administration was in office. Well, just the other day, the courts dismissed the case against the Department of Education that was filed by the state of Missouri and also some other states as well. We know the state of Missouri, they filed this complaint because this is where Mohila is housed, which is the biggest student loan servicer. And what their complaint is basically, and as you can see in this information here, you can see directly on Court Listener. If you like to read case law, you can go to Court Listener, you can create a profile, and you can just sign up for alerts. I make sure that I get alerts for things that's dealing with the SAVE plan, the lawsuit by the American Federation of Teachers, and also the Sweet versus McMahon settlement and other cases I keep up with as well. But if you are enrolled in a SAVE plan, then this stuff is important to you. But for me, when I read this information, especially about these states and just recently with the department, I'm sorry, with the courts dismissing the motion, basically stating that they don't want to be involved. They're not going to be involved because at the end of the day, when we talk about this settlement agreement that was dismissed or this motion that was dismissed, the courts are basically stating that at the end of the day, the Trump administration has already stated that they're going to phase out the SAVE plan. That's going to happen by July of 2028, unless they go through a negotiated rulemaking process, which could actually repeal the plan a lot sooner. But we know currently, as it stands, July of 2028 is when this plan is supposed to be phased out. Now, the plan could have been phased out sooner if this settlement agreement with the state of Missouri and the Department of Education, if the courts approved it, but they did not. They're saying, hey, this needs the Department of Education. You need to go deal with the Department of Education because it's well within their realm to be able to, if they want to, get rid of the SAVE plan a lot sooner. But for me, even though I know the face of it is just getting rid of the SAVE plan, but when you look at the settlement agreement within itself and the reason why the state of Missouri and these other states are going so hard is because there's other things in that settlement agreement to me that I feel like this is why they have now because there was a stay. So basically, what they did after the courts dismissed it, and this was on the 27th of February, when the courts put in that order of dismissal, basically saying they're not going to deal with it, they don't want anything to do with it. It's not necessary for them to intervene when basically you two have already agreed to do the same thing. You don't want the SAVE plan, state of Missouri, any other states. Also, the Department of Education, the Trump administration, you don't want the SAVE plan either. You're going to get rid of it. That's going to happen. So, what are we arguing about? But like I said, when you read the actual Missouri settlement and what it is that they're asking from the Department of Education to do and why this settlement is so important to them, because we have to remember, as student loan borrowers, there's interest that's connected, there's money, there's funds, there's people that are invested in these student loans that makes billions of dollars. So when we have a state like Missouri and these other states as well, where we've got loan services and there's revenue that is coming into these states, they want all the money. And by canceling debt or discharging debt under certain plans, they start to lose money, and it's a lot of money in that interest. So when we look at this document, where the not only was the order dismissed, then the states filed a motion to stay, basically because they're going to appeal it. They're going to take it to the Eighth Circuit Court. They want to take it to a higher court because they're like, okay, well, while we're appealing it to this higher court, go ahead and put a pause on that dismissal because we're appealing it. And basically, what came back today is the court said, well, absolutely not. We're not going to put a pause on this dismissal while you file this appeal in the higher court. We're not going to do that. And they tell you why. And it was actually interesting to read. So let me show you really quickly the settlement agreement, okay? These are the things that Missouri was wanting. The state of Missouri and these other states are wanting in this settlement. And this is if it was approved, and this is what they're appealing to the higher courts for, okay? And I did a video about this way back then because in this settlement will be extended way after the current administration is out of office. This is just, let's read it, okay? So it tells you in this settlement agreement, this is what was dismissed in the courts, okay? The state of Missouri, they give you the other states, Arkansas or Arkansas, however you say it, Florida, Georgia, North Dakota, Ohio, where I'm at, of course, and Oklahoma, and the United States Department of Education, Linda McMahon, in her official capacity as Secretary of Education, and President Donald J. Trump in his official capacity as the president, defendants and collectively the parties hereby enter into this settlement agreement. This is if it was approved, okay? Plaintiff's relief and dismissal of claims. Upon the execution of this settlement agreement, plaintiffs hereby release and forever discharge defendants, their successors, the United States of America, and any department, agency, or establishment of the United States, and any officers, employees, agents, successors, or assigns of such department, agency, or establishments from any and all claims and causes of actions that plaintiffs assert or could have asserted in this litigation, or which hereinafter could be asserted by reason of or with respect to or in connection with or which arise out of the causes of action alleged in the complaint. Upon the execution of the settlement agreement, plaintiffs hereby release and forever discharge defendants, their successors, they go on and go on. Future claims for attorneys' fees, costs of litigation, expenses in connection with the above captioned litigation. Definition. The SAVE plan is defined as the income contingent repayment plan, also known as Saving on a Valuable Education, created in 2023 as a revision to repay plan under the authority of Section 455 of the Higher Education Act of 1965. They give you the section of the Higher Education Act and all the other information. The SAVE plan final rule is defined as the final rule published on July 10th, 2023. The repay is defined as the income contingent repayment plan, also known as revised pay as you earn, created in 2015. They give you the section of the Higher Education Act. They go on to tell you the same thing, the definition of pay plan and when it was created, okay? Plaintiff duties and obligations. Oh, they tell you the original ICR is defined as the income contingent as well. So these are all plans that were created by the Department of Education. This is why they're telling you about the plan, when it was created, and all of those things. Plaintiff duties and obligations. Concurrent with the execution of the settlement agreement, plaintiff's counsel shall file the joint motion for entry of final judgment that is attached to the settlement agreement. Plaintiff shall not include the settlement agreement as an attachment to the filing. Defendants' duties and obligations. This is the Department of Education. Defendants will not forgive loans under the SAVE plan or under repay plan using the Department of Education's income contingent repayment authority, as it was interpreted by the SAVE plan final rule. However, nothing in the settlement agreement shall prevent the Department of Education from forgiving loans of individuals currently enrolled in the SAVE plan using a separate source of legal authority, such as borrowed offense repayment, discharge due to borrower's death, total and permanent discharge, closed school discharge, or public service loan forgiveness. So basically, we know if you have any of these pathways to get your student loans discharged, which is borrowed offense, if you pass away, of course, total and permanent disability, closed school discharge, or public service loan forgiveness, all programs that were created through Congress or authorized through Congress. Basically, what they're stating is that you can go ahead, if the borrower is enrolled in the SAVE plan, go ahead and discharge. You can still discharge under those particular programs under this agreement, okay? With one exception. Defendants will not implement any provisions of the SAVE plan final rule. The exception is for the provision concerning the periods of deferment or forbearance that are counted towards eligibility for loan forgiveness under income general repayment plans, which is codified, and they give you the section of the regulation, which took effect on July 1st, 2024, and the legality of which was never challenged in this case. That provision will remain in effect. Defendants will not enroll any new borrowers in the SAVE plan, will deny any pending enrollment applications. Oops, where was I at? Oh, where did I miss? I scrolled. Oh, where was I? Jeez, oh, Pete's. Oh, where was I? I think I was down here. All right. Yeah, defendants will not enroll any new borrowers in the SAVE plan, will deny any pending enrollment applications for the SAVE plan, and will continue working to move all current borrowers out of the SAVE plan. Defendants will likewise not enforce the original repay rule or otherwise enroll any borrowers, including SAVE borrowers, into the original repay plan. Defendants will pursue negotiated rulemaking to effectuate the settlement. As part of that negotiated rulemaking, the Department of Education will consider a formal complete repeal of the SAVE plan final rule, sunsetting the original ICR plan. They give you the section of the regulation, and sunsetting the pay plan, give you the regulation consistent with 82001C of the One Big Beautiful Bill Act. Defendants have not prejudged the outcome of that negotiated rulemaking session to the extent that the Department of Education retains any policy discretion on these subjects in the aftermath of the enactment of the OBB, One Big Beautiful Bill Act. Anytime the defendants plan to or have reason to believe that they will cancel or forgive more than $10 billion in federal student loans within a month period, the Department of Education or its successors. So this is why I said, even after the Trump administration is out of office, they're saying its successors shall provide written notice to the Office of the Attorney General of Missouri at least 30 days before cancellation or forgiveness, identifying the basis for the defendant's legal authority and how much they estimate will be forgiven or canceled. If defendants do not provide written notice under the previous sentence, but actually did forgive more than $10 billion in a federal student loans within a 1-month period, the Department of Education or its successors shall provide written notice to the Office of the Attorney General of Missouri within 30 days after the end of such month. This provision will expire 10 years after the date of this settlement agreement. So do we see just here why this is so important for them to get this settlement approved? Miscellaneous provisions. Each undersigned representative certifies that he or she is fully authorized to enter into the terms and conditions of this settlement agreement and to execute and legally bind the parties he or she represents to this document. The parties acknowledge that the settlement agreement is entered into solely for the purpose of settling and compromising the claims in this action without further litigation, and that it shall not be construed as evidence or an admission regarding any issues of law or fact regarding the truth or validity of any allegations or claim raised in this action, or as evidence or as an admission by defendants regarding plaintiff's entitlement to any relief, including attorney fees or other litigation costs, or regarding the propriety of the venue in this district. This settlement agreement is intended to create and does not create any third-party beneficiary rights and other kind of right or privilege for any person, group, or entity. Nothing contained in the agreement shall impose on defendants any duty, obligation, or requirement, the performance of which would be inconsistent with federal law in effect at the time of such performance. The agreement constitutes the entire agreement among the parties and supersedes all prior representations, agreements, and understandings, whether oral or written, concerning the subject matter of this settlement agreement. The agreement may be executed in counterparts and is effective on the date by which all parties have executed this agreement. Facsimiles and PDF versions of signatures, including electronic signatures, shall constitute acceptable binding signatures for purposes of the agreement. The agreement is binding on the parties, their successors in office, employees, representatives, delegates, agents, and assigns all persons acting on their behalf to extent permitted by law or required by settlement agreement. Failure by any party to enforce this entire agreement or any provision thereof shall not be construed as a waiver, including of its rights to enforce any other provisions of the settlement agreement. So stipulated and agreed on this 9th day of December, 2025. So we see why the state of Missouri is going so hard to appeal this. You know, there's so much at stake here for them as a state and all of the rest of them, because we're talking about money, big revenue that these states make on student loans, the interest, the collection, when a borrower goes into default, just the making of a student loan, the servicing of the loan, the amount of money that these states stand to make. And when you have a Department of Education that they feel is just going to be going around canceling a bunch of debt or discharging a bunch of debt, student loan debt, that they lose money. So at the end of the day, that's what it's about. But when you read the settlement agreement and what they stand to gain by this agreement being executed, they're not going to just lay down and not continue to take this up to the higher courts. But I do believe, just if you read, and I have my video prior to this where I actually went over the order, because when they filed this motion to stay, the court denied it. They denied that today, March 4th, it was denied. So when you read this motion to stay, and the reason why the courts actually, their reason behind them denying it, because it doesn't cause them any irreparable harm and other things as well, it's wild. But it's interesting. If you I don't know, for not everyone it's fun to read cases, but when you read these things that are happening, especially when you are living in this stuff in real time, it is absolutely wild what money, in a sense, will do. There's no care about what this does to borrowers who are in the SAVE plan, who are currently, just wanting some kind of clarity and some finality in all of this. Either, take the plan away completely, go through the process, the negotiated rulemaking process, get rid of the plan immediately, or, start processing some discharges and let borrowers make payments, under. This repayment plan. So it's just all of that. But we'll see what happens. We'll definitely see what happens.